Good morning, Your Honors. David Rosenberg on behalf of the appellant, U.S. Bank.
Judge Kelly, I believe you're muted.
So thank you. Mr. Michaels and Mr. Heller, how are you all going to use your time?
Well, I'm going to defer to Mr. Heller, the majority lion's share of the time. I represent the Boyvens, Robert and Teresa. And so I would just ask for 5 of the 20 minutes and let him take it away.
Okay.
That's fine.
All right. All right. Thank you. And Mr. Rosenberg, sorry, I'm ready for you to start now.
Of course, Your Honor. Good morning. My name is David Rosenberg. I represent the appellant, U.S. Bank. If I'd like to reserve 5 minutes for rebuttal, if it pleases the court. This is an appeal over whether the Vanderbergs presented sufficient evidence to support a finding of laches. The Vanderbergs claim that we want this court to reweigh the evidence. Nothing could be further from the truth. We do not take issue with any of Mr. Vanderberg's testimony.
Can I jump in here and just ask you about the time frame so I can get this straight in my mind? So basically, the bank waited from 2013, from the last prior foreclosure, to 2020 to institute this foreclosure action. So there's a 7-year period of time in there where the bank was doing nothing. And you list the various things in your brief about what was going on. There were efforts to settle. Then Mr. Boyven died in this. Then you have a bank, the bank placed a compliance hold on the file. What does that mean?
Yes, Your Honor. So there were FEMA moratorium holds on the file. This was due to hurricanes, and then you also had COVID during that
Well, I see
period.
the FEMA ones, but that's not the one I'm asking about. It says compliance hold, and it occurs shortly after he died. Does that mean you're talking with the heirs, or what does that mean? Or do you know? If you don't know, tell me you don't know.
Well, Your Honor, I only know what the witness said, of course, and he testified that after Maurice Boyven passed away, they tried to work with the heirs and they placed a compliance hold on the file. Now, my understanding from the witness's testimony is that it's exactly what Your Honor said, which is that they were trying to determine what to do with the property, and perhaps if heirs want to take it over or something like that. But the witness doesn't get into it, so I can't also without going outside the record, of course.
Well, and then there were some FEMA moratoriums in 2017, 2018, 2019, and 2020. I assume those are hurricane situations, I'm guessing?
Yes, Your Honor.
Okay, so these holds, I can't imagine, went for a whole long time.
Your Honor, the witness testified that it was over those 3-year periods.
Well, it's 4 years, 17, 18, 19, and 20.
That's right, 17 to 18.
There were holds, and supposedly they were FEMA hurricane related. Again, it doesn't sound like there were continuous holds over that 4-year period. It sounds like there was a hold and maybe it opened up again in that situation. So that's part of what you've argued is why laches doesn't apply, is because of these things that intervene. Is that fair to say? Is that part of your argument?
That is part, but it is actually, I would suggest, a minor part of the argument overall.
Okay, well, then let me ask a few more questions and I'll leave you alone. So in February of 2020, I think I have my dates right, the Vanderbergs acquired the property at this judicial sale in the city of Largo. Is that correct?
Yes, Your Honor.
And less than a month later, you start to foreclose again. Is that right?
Yes. So they received title on February 3rd of 2020.
Okay.
Purchased it in January. They received title on February 3rd of 2020, and then on February 12th of 2020, so 9 days later, we file suit.
Okay. And then you learn of them later and you add them as an indispensable party. Remind me the date when you learned of them and added them.
It was October 7th, 2021, Your Honor.
So it's a year and a half later,
Yes, Your
year
Honor.
and a half later. So in that year and a half interval, you filed a foreclosure action. You don't know anything about them. You don't realize that they've acquired title. They don't know anything about your foreclosure action, right? Because you didn't add them until a year and a half later. So in the interim, they spent $172,000 fixing the property, paying taxes, paying for insurance, because nobody's communicating and nobody's realizing that each other is involved. Is that right? So all this problem occurred in that 1.5 year window when they didn't know about you and you didn't know about them.
Yes, Your Honor, that's correct.
Okay, that helps me understand this then. Okay, I appreciate it. Take it from there.
Sure, of course. So now I'd like to address something the Vanderbergs raised in their brief. They argue that we want this court to reweigh the evidence, reweigh the testimony, that we're trying to relitigate this on appeal. And I said it again, I said it before, I'll say it again, nothing could be further from the truth. We don't take issue with any of Mr. Vanderberg's testimony. This court can and should accept all of his testimony as true. The problem, however, is that Mr. Vanderberg's testimony does not support a finding of laches. Now, laches requires a showing that a party detrimentally relied on the other party's delay in asserting a right. Now, Vanderberg and his counsel are happy to talk about the delay aspect of that. His entire defense is predicated on the 2 prior unsuccessful cases. His counsel spills much ink detailing the delays and issues and that 7-year period that Your Honor, Judge Morris mentioned between the last unsuccessful case and this case. And I'm sure you'll hear all about that again when my colleague gets his turn to speak. But laches does not just require a delay. It also requires a reliance on that delay. There has to be a causal connection between the two. And the Vanderbergs entirely failed to prove any reliance on the prior 2 cases. In fact, to the contrary, Mr. Vanderberg testified that he had no idea about the prior unsuccessful foreclosure actions when he purchased the property. He knew about the mortgage. He testified that he knew about the mortgage, but when asked by our trial counsel, did you know about the 2 prior cases, the 2 prior unsuccessful foreclosure actions, he said no. He said, no, sir, he did not. And indeed, Mr. Vanderberg testified that had he known of the prior lawsuits, these are his words, I wouldn't have purchased it. It's transcript page 118. We would submit this is the very opposite of detrimental reliance. The Vanderbergs are happy to talk about the delay, and his counsel's arguments strongly imply, if not state, that the delay between the last unsuccessful case and this case caused Mr. Vanderberg to purchase the property, but his counsel's arguments don't match the evidence. Mr. Vanderberg did not know about the prior cases. He didn't rely on the prior cases. There is no connection between the prior cases and his purchase of the property. What he testified is that he knew about the mortgage. He talked to a title agent, but the testimony was cut off because an objection on hearsay was sustained. And
that actually ties into a question I had, because I recall that there's this attempt to get in like an off-the-cuff conversation he had with the title agent. There's some mention of, I did an internet search. I don't know what that means, but presumably he looked through the clerk of the circuit court records about whatever liens there are. Is there anything else in the record that suggests that this gentleman did any kind of title search, got any kind of title commitment, got any kind of, ownership encumbrances, lien report, anything like that? Or is it just, does the record just reflect he basically looked at the internet and may have talked to a title agent, but we'll never know what was said?
So, Your Honor, it doesn't reflect any title insurance, but the record does reflect a title report. Mr. Vanderberg testified that he did look at a title report. He actually is a building inspector, so he says he's familiar with checking liens, and he looked at a title report, and the title report stated there were no other lawsuits filed regarding the property, and that the mortgage was on the title report. This is
and that's what I wanted to kind of pin down a little bit. Was that title report admitted into evidence?
No, Your Honor.
Okay. And my concern is that a title report is one thing and an internet search is another thing. And a lay witness who's not a title agent or a lawyer may conflate the two. So, like, if you can just point me to the record where where I could find exactly what was said about what he's calling a title report. Because to get a title report, you actually got to hire a title agent. You got to pay for it. You actually get a report issued to you. It comes in a certain format. It's subject to certain. I mean like the different. There's only a handful, but the different agencies have certain kind of check the box things that they do on it. It's going to read a certain way, as opposed to, well, I printed out something or I had somebody look at something on the clerk of court website. That's what I'm trying to drive at. It may not matter because it's a recorded mortgage and that's public record and it's 30 years and okay, there it is. But can you just hone me in where in the record I should be focusing on?
Sure, Your Honor. It is record site 1915 to 1916. It's page 117 to 118 of the transcript. And it goes from there. And Your Honor, he does use both terms. He uses title search and title report. So whether he's completely...
and that was where I was a little, okay. So that's it. That's all we got. Okay.
Yes, Your Honor. So then he also testified that, as Your Honor noted, he did some internet searches, and he also did not look at any court docket or anything like that. So this is all he did, is he looked at a title search or title report. He saw there was a mortgage on the property. For some reason, he disregarded the mortgage, and that's it. That's all the diligence he did before he purchased the property. So Mr. Vanderberg argued below successfully, and he argues again on appeal, all about the prior foreclosure actions, and he paints a very poor picture of my client, talking about the 7-year delay and everything my client did or didn't do. But I would submit that's really, to a large extent, irrelevant, because Mr. Vanderberg didn't know about the prior lawsuits when he purchased the property. He did not rely on the prior lawsuits. He didn't know about the default date. He didn't know about the 2 dismissals, or the last one was in 2013. He didn't know about any of that. He candidly testified that had he known of the prior lawsuits, his words, I wouldn't have purchased it. Very opposite, again, of detrimental reliance. And refer this court to Smith v. Branch, which we talk about a lot in our briefs. It's from 1980, so slightly dated, but still very good law. And this court reversed the finding of laches, where the appellee was, quote, well aware of the existence of the mortgage in question and, quote, did not establish that he had ever been given reason to believe that the mortgage would not ever be foreclosed. And that's what we have here. We have someone who did a very perfunctory cursory search, saw the mortgage, disregarded it for reasons that are not part of the record, didn't do an appraisal to even find out what the property was worth, and purchased it at a judicial sale. So this is what I would want to ask the Vanderbergs counsel, and it's what we tried to ask in our brief, is we would ask them to say, where in the transcript did the Vanderbergs testify that they relied on any delay by U.S. Bank? Because that's our argument, is that U.S. Bank delayed in filing the suit. But where in the transcripts did Mr. Vanderberg testify that he relied on the delay? Where did he testify that he knew about the delay? How can the trial court find laches where Mr. Vanderberg testified that had he known of the prior lawsuits, his words again, I wouldn't have purchased it? I do sympathize, of course, with their plight slightly, because I don't think that they conducted due diligence, but at the same time, they didn't even conduct an appraisal before buying the property. It's difficult for me to understand how somebody could buy a property when you look at a title search or title report, you see there's a recorded mortgage on there. You don't see anything satisfying or extinguishing the mortgage, and you buy the property anyway. This is, in my opinion, I mean, this is the definition of caveat emptor, right? And that case law on caveat emptor is voluminous. And under that rule, a purchaser at a judicial sale takes title, subject to everything of which he had notice or which he could have obtained knowledge in the exercise of ordinary prudence and caution. And I think a good example, Judge Kelly in U.S. Bank v. Rios, is one of your decisions from 2015. A person purchased a property at a judicial sale. On the very day of the sale, there was sinkhole activity on the property, and the purchaser tried to get out of the sale. The trial court felt sympathetic to them apparently and vacated the sale. And on appeal, this court reversed, finding a purchaser of property at a judicial sale is generally subject to the rule of caveat emptor. And I think that this is the situation we have here. Is there were a lot of perhaps emotions or sympathies at play in the trial court, but at the end of the day, the Vanderbergs did not elicit the necessary evidence, the sufficient evidence to sustain a finding of laches. And again, I'm sure my colleague will get up and talk about that 7-year delay and the length of time, but none of that really matters because Mr. Vanderberg didn't know about any of that when he purchased the property. I'd also note, of course, regarding the delay itself, the mortgage doesn't mature until July 1st, 2036, according to recorded mortgage, of which Mr. Vanderberg knew and had knowledge of. And so he should have known that if he bought this property, there was certainly a chance that the mortgagee would initiate foreclosure proceedings on or before that date. And if this court has no further...
have made an issue about the default that was declared in the 2013 foreclosure that was dismissed for failure to prosecute, that the default date was August 1. I forgot the year, but it's August 1. And then the default date in your current foreclosure was the exact same default date. Does that matter?
Well, Your Honor, I don't think it matters for two reasons. One, that's actually not a correct statement by my colleague, counsel for the Vanderbergs. The default date in the prior case was August 2010. Our action was August 2010 and all subsequent defaults. And so we put into play a different series of defaults that existed in the prior foreclosure case. Now, I also don't think it matters because our right to foreclose doesn't accrue upon a default. And that's according to the terms of the mortgage of which Mr. Vanderberg acknowledged. Under Ballatieri, which the reasoning of which this court adopted in Gerdick, a mortgagee's right to foreclose doesn't normally accrue until the mortgage loan matures unless the lender voluntarily elects to accelerate an earlier date. So we didn't have to do anything until 2036. I mean, we could sit back and let Mr. Vanderberg spend more money on the property and then foreclose in 2036. Instead of filing suit late, my client filed suit 16 years early.
Sir, you're at your 5 minutes.
Yes, Your Honor. Thank you. If the court has no further questions in the interim, I'll save the rest for rebuttal.
All righty. Mr. Heller, are you going to go first?
I'm happy to. If Mr. Michaels prefers to begin, that's fine too.
Mr. Heller, take it away.
Okay. May it please the court, Judge Kelly, Judge Morris, Judge Lucas. My name is Samuel Heller, and I represent William and Tiffany Vanderberg in this appeal. I wanted to start, Judge Morris, by speaking to some of the timeline questions that you had at the beginning of Mr. Rosenberg's presentation. The witness for U.S. Bank, Miss Lee, did testify as to certain holds. When she was asked these questions, her testimony was, I think there was a hold for various reasons, and those spanned 2017 to 2019. But there was never any specific testimony of any kind as to what the beginning of a hold was and the termination of that hold. And all of her testimony was based on what she thought she recalled having seen when she reviewed the file. And so there is no definitive position or definitive testimony regarding the time span or existence of any particular hold. At the same time, Judge Lucas, when you were asking questions about the title reports and things of that nature, there's a critical component of, and I disagree with Mr. Rosenberg that reliance is an element of laches, and I'll speak to that in a moment. But one of the critical components of Mr. Vanderberg's testimony was that he had visited the property and it was clear to him that the property had been abandoned since at least 2008. There were large holes in the roof. There was damaged trusses that were exposed. And so it was his observations. And again, I disagree about the legal requirement of reliance, but to the extent that there was testimony about what he observed and the decisions that he made in going into this, it was the fact that this was a abandoned piece of property for at least the 12 years preceding.
Here's
that kind of led
here's
him.
the problem that I perceive with that. That for purposes of occupancy, that may very well be true. He may very well have reasonably concluded that this property is not occupied. But there was a recorded 30-year mortgage. There's no evidence that a satisfaction of that mortgage had ever been recorded or that a judgment had ever been entered on that mortgage that extinguished it, which means he's on, better or worse, caveat emptor. I mean, it could have been vacant, it could have been leveled, it could have been dirt, right?
Understood.
There's a 30-year lien on it because the 30-year lien corresponds to a 30-year note, which means whoever extended that note and extended that debt and has a lien on that property has a right to collect on that note that's secured by that dirt. So help me out with that.
Yes, Your Honor. And I agree with everything that you just said.
Okay.
And that kind of dovetails into the reliance component. U.S. Bank spends a significant amount of its brief arguing constructive notice, constructive knowledge of a variety of components of the mortgage. And Mr. Vanderberg readily acknowledges that he was aware of the existence of the mortgage. And I think if the court would have allowed some of this testimony in regarding the conversations with the title agent, there'd be a little bit more clarity of that. But in that respect, if Mr. Vanderberg and Ms. Vanderberg are charged with constructive knowledge of what's in recorded documents, then they're also charged with constructive knowledge about the existence of the foreclosure cases. And it's important to note in response to what the judge...
I mean, I would actually have to push back against that, because here's the thing about that. The way that plays out is there's an LP that gets filed. So the way you construe title and the way you construe whether or not you're getting title is you look at the recorded instruments. Is there a lien, a mortgage? Yep, there it is, 30 years. Are there any lis pendens filed as to any lawsuits? Yes or no? If there's not, okay, you still got the lien to deal with. So I have a hard time understanding how constructive knowledge, how you weave in the court docket of prior foreclosure cases as an element of constructive knowledge of what he did at the time he made the purchase at the judicial sale, given his testimony that if he had had any clue about these foreclosure cases, he would have done it.
My point in making that comment, Your Honor, is the inconsistency in the position taken by U.S. Bank, not an inconsistency in the position taken by Mr. Vanderberg. And in that respect, there is no case law that we have identified, and none of the case law that's cited by U.S. Bank that supports the proposition of a requirement of due diligence or reliance on the part of, in this case, the Vanderbergs. When you talk about the diligence that is required in the context of laches, you're talking about U.S. Bank. The only cases that are cited in U.S. Bank's brief that speak to a reliance component are in child support cases where the reliance or the issue is the passage of time. In none of the cases dealing with real property, whether it's foreclosure or otherwise, whether it's cited in U.S. Bank or the Vanderbergs brief, reliance is not a component. And in that respect, Smith v. Branch, which is a case that is heavily relied upon by U.S. Bank and referenced by Mr. Rosenberg, there's no reliance component there. The issue in Smith v. Branch was specific discussions between the second mortgage holder and the borrower at the time of acquisition of the property, where the lender, the second mortgage holder, had made representations or stated that they were not pursuing it because they didn't think there was enough equity in the property. And
well,
so
let me turn that around on you. Have you cited any cases where laches has been applied against a party who has an interest that is against a party whose loan or lien interest has not yet expired? In other words, that where the laches arises after the expiration of the final due date. Is there a case out there where it applies laches like that?
Ratner is that procedural posture, but speaking to the same issue is the Avello mortgage case that is cited in both U.S. Bank and the Vanderbergs briefs. And in that respect, what I think the critical component is is that in this case, U.S. Bank, and this, Judge Morris, speaks to some of your colloquy with Mr. Rosenberg about U.S. Bank didn't know about Vanderbergs, Vanderbergs didn't know about U.S. Bank. U.S. Bank was named initially as a defendant in the Largo Code lien and foreclosure matter. And so it was specifically put on notice of the existence of that foreclosure action. We're not taking the position that U.S. Bank was required to participate. They were properly dropped shortly thereafter. But it certainly was put on notice that this property was going to be sold. And so whether it was the Vanderbergs or somebody else, they knew that there was going to be a new owner down the road. And it specifically waited until after that certificate of lien.
But here's the thing. I got to circle back. You said Ratner supports the scenario that I laid out. In Ratner, it says the subject mortgage and note were signed as a really short-term mortgage, were signed on June 1st, 1961 and reflect a maturity date of December 1st, 1961. It was not until 1974 that the mortgagees first attempted to collect on the note. That's not what we have here. The maturity date on this hasn't even come yet.
Judge Lucas, I thought your question was whether or not there was a case that we cited or that I could point to where the enforcement came after statute of limitations period.
No, that's a whole separate issue. This is has the debt matured? Has the lien ended and the debt matured? And the answer to that is no. And there's no case that supports applying latches in that instance.
Your Honor, I agree with
you.
You
want us to break new ground? That's fine, but give me a good pitch as to why we should break new ground on that.
The cases that we have cited specifically say that, generally speaking, statute of limitations and the accrual of the maturity date is one of the key benchmarks. But what we're talking about and what the cases specifically say is that statute of limitations doesn't necessarily apply when equity requires a different result. And we cited multiple cases for that proposition.
Okay, so I'm reading between the lines here. I mean, I'm glad we're drilling down like this. I'm reading between the lines. What you're kind of asking us to do is rethink or reframe the prior holdings that have said, hey, upon a new breach, a new monthly payment installment miss, you can reaccelerate, and statute of limitations isn't going to bar all of the prior missed payments. It kind of sounds like you're asking us to revisit that, which I don't.
No, I think the holdings and the statements of law within all the cases are appropriate, and I don't think it's an extension. And I don't think it's an extension because in all of these cases, and the cases specifically speak to the fact that these are highly specific and factual determinative based upon the individual sequences. And so what you have is you have the second foreclosure action being filed in 2011. That is after the 2009 case was dismissed following a modification. You have a default August 1st, 2010. That default date is the basis for the acceleration and the initiation of the 2011 foreclosure case. No action taken, it's dismissed for failure to prosecute. The case sits there, and no action is taken between May of 2013 and 13 days or 12 days after the bank had notice of a lien foreclosure action and the issuance of a certificate of title. It then files an action, and only 3 months after the Vanderbergs complete their expenditure of $172,000 is that lawsuit amended to bring in this additional party.
Yeah, and so you're going to be making a pitch to equity. Basically, like this equity ought to be driving the latches determination, and forget caveat emptor. In this situation, equity should triumph over what otherwise might be a caveat emptor scenario.
That has been the Vanderberg's position through trial court. That has been our position through the briefs. That is our position today, because we're not disputing the fact that that U.S. Bank had the option of accelerating at any point beginning in August 2010 through 2036. But it is the specific sequence of events, the inclusion of the same default date in both cases, the knowledge of having been named in the City of Largo lien foreclosure action, sitting and waiting for the issuance of the certificate of title to file an action that does not include that new owner, and then upon completion of a total rehab of a property to the tune of $172,000 to repair what the bank obviously would have known the condition of the property as well, and Ms. Lee speaks to that, although she didn't have specifics. You have all of these things that speak to whether or not equity would support the conclusion that the court reached. And
well, let me ask you how far you would take this. Suppose you had 30-year note, 30-year mortgage. After year one, there's a default. Guy moves out, bank doesn't collect, but the bank just lets it go and lets it go and lets it go because they see that the asset that is securing their note is appreciating in value. And really, why should we hurry things up? Because we've got a recorded mortgage, we've got a note, and we are entitled to use this property to collect on that. And they just let the interest accrue. And lo and behold, at the end of 30 years, okay, now we're going to pull the trigger. And we're going to collect all of that interest that we were entitled to collect under the note that we extended, right? I mean, that was the deal originally. Would you suggest that in the instance where somebody came along in the interim and got title subject to the mortgage in a junior lien foreclosure, that nope, sorry, you lose the benefit of your bargain, you lose everything. Would equity take you there?
The Avello mortgage case is the exact situation that you're describing, and it's the corollary to what the Vanderbergs did. And this is why it's fact specific, and that's why we're appealing to the equity side of the court. In Avello mortgage, you had a tax deed where a purchaser acquired a piece of property subject to a mortgage. He raised the affirmative defense of laches, and the court denied the laches defense and granted the foreclosure because in that case, the owner had only owned the property for 3 months, and there was no evidence presented as to what improvements, if any, that the owner had done in the interim. And so the mere holding of title by that purchaser was not enough to support a finding of laches. Different from the Vanderbergs, where between the time that they took title and when they were named, they spent $172,000 and they continued to pay property insurance and taxes during the pendency of this action. At no time did U.S. Bank make payment towards any of what would ordinarily be escrow advances or things of that nature. U.S. Bank allowed for the Vanderbergs.
Your reliance on Avello is as a contradistinction because in that case, the court actually held that the mortgage was valid.
Correct. And that was speaking to your question, Judge Lucas, in terms of where does equity begin and where does equity end? And that's why it depends on the circumstances of each case. If the Vanderbergs had taken title to the property, but were living in it with a hole in the roof and living in it as is, I think the analysis would be extremely different. I think that if the Vanderbergs were named in the foreclosure action when filed and continued to make improvements towards the property during the pendency of that action, this would be a very different argument. But the U.S. Bank, after having been named in the lien foreclosure action, files suit 12 days after certificate title issues. And it's not until after that expenditure and those improvements on the property are made are the Vanderbergs ever first served with and named in this action. And so, again, when we take, the concepts.
Mr. Heller, I'm sorry. I just want to let you know there's 5 minutes left.
Thank you, Judge Kelly. I'll defer to Mr. Michaels unless the panel has any further questions for me.
No. Mr. Michaels? You're muted, sir. Mr. Michaels, you're muted.
Now you can hear me. Good morning, everybody. Yeah, I represent Robert and Teresa Boyven. Their only involvement was that they were one of the original title owners with Maurice Boyven, who borrowed all the money. And so because of that, their sole involvement was signature on the mortgage to secure the loan. The mortgage itself says they're not personally liable. The appellants and their reply brief to our affirmative defenses, and the appellant in their reply in this appeal have admitted throughout there is no personal liability for monetary liability concerning the Boyvens, my clients. So for lack of a better term, I'm sort of their legal guardian, watchdog, just to make sure there's no issue or problem, misentry, that there's no judgment against them monetarily. And that would hold true as well if the court considers attorney's fees and costs for the appellant. And that's about it. Any questions? Thank you.
No, sir. Okay, Mr. Rosenberg, your rebuttal. You've got 5 minutes. No, I'm sorry, 3. You asked for 3, correct? Yeah. All right.
Thank you, Your Honor. So my colleague, Mr. Heller, he argued that reliance was not a critical element of laches. And then he cited, in support of his position later on, Avello mortgage. Avello says that prejudice for laches results when there is a loss or injury to a person who relies on another person's voluntary failure to exercise a legal right. Without reliance, what do you have here? You have someone who knew there was a mortgage on the property, spoke to a title agent about something that's on the record, didn't conduct an appraisal, and bought the property. That's it. I certainly understand that the Vanderbergs expended money on the property, but that is why you have the doctrine of caveat emptor. They purchased the property at a judicial sale. And Mr. Heller refers this court to the equities, but laches requires a showing of certain proof. All you have here, as this court has recognized, is Mr. Vanderberg purchasing the property subject to a mortgage and spending money on it. U.S. Bank testified they never knew, condoned, or encouraged any of this. U.S. Bank properly recorded its mortgage in 2006, and I understand that Mr. Vanderberg has buyer's remorse and apparently regrets his purchase of the property, but that is not U.S. Bank's fault.
Mr. Rosenberg, you have read in the briefing, you've heard just mentioned again by your opponent, that at the time of the lien foreclosure by the city of Largo, your client, the bank, was named as a defendant initially and then later dropped presumptively because it had a superior lien to the claim of lien. I'm assuming that that's what happened. And but nevertheless, because of that process, they did in fact have actual knowledge that the Vanderbergs were, or at least there was a lien foreclosure action, and that somebody was likely to buy this property at a judicial sale. And they apparently did not act on that at all, but they had actual knowledge that that process was going on and would result in presumptively a sale where someone bought. I mean, how do you explain this 18-month period of time with this knowledge that they had because of this lien foreclosure action, which they were a named party to initially?
Yes, Your Honor, 2 responses to that. First, that is not why the trial court found laches. It had nothing to do with the city of Largo foreclosure action or that 18th month period. That wasn't part of the trial court's analysis. The trial court focused on the prior foreclosure cases and finding that there was laches. And that's what we're seeking to reverse, is that finding. The trial court never found that there's laches regarding the 18th month period. The second thing I'd say is that the evidence reflects that my client did do a title report. And then because there was this 3-day period between when title was issued and the complaint was filed, the new suit was filed, they happened to miss it. But the focus is...
Well, my reason for bringing that up is because you just said they did not have knowledge that the Vanderbergs bought, paid, and proved. You just said that, which is why I said they must have had knowledge because of this. And now you've decided that's not important.
Well, Your Honor, just during that 18-month period, the U.S. Bank's witness testified that they didn't know about any of the improvements that the Vanderbergs were making. They didn't encourage it in them. They didn't benefit from them. I mean, my client doesn't have...
Well, hang on. The bank substantially benefits from it because they're seeking $615,000 judgment by virtue of their foreclosure. And but for the Vanderbergs' improvement, this property would probably be worth 1/3 of that.
Well, the amount that my client is seeking is not tied to the fair market value. The fair market value will be determined at any eventual sale. The amount that my client is seeking is the amount that's entitled to under the mortgage that it recorded in 2006, and that matures on July 1st, 2036.
Your client has a better chance of being made whole because of what the Vanderbergs did than they would have had the Vanderbergs not done anything.
Perhaps, yes. I mean, I would agree, perhaps, Your Honor, but that is not what laches tests. Laches tests whether somebody relied on another party's failure to timely exercise their right, and there's just no evidence of that here. The evidence only establishes that the Vanderbergs didn't conduct due diligence and purchased their property knowing there was a mortgage on the property, and that's it. And everything else is conjecture and hearsay.
Gentlemen, thank you all. Good arguments.
Thank you,
And
Honor.
that concludes this case. We're going to take about a 10-minute break and we'll return to finish our docket.
Thank you.